Okay, so I think it's time for us to begin now. We'll start with providing giving an introduction and thanking our speaker today, and thanking all of the people who have joined already on this talk. I want to start by telling our public that today's lecture, or today's conversation, will be undertaken in English language. We have with us today the honor and the privilege to have Professor Alan Palmeter joining us from his headquarters in Winston-Salem. Professor Palmeter, it is a pleasure to have you with us here, to receive you, to have this short conversation. Before I introduce you, I want to thank the organizers of this event, the Semillero de Derecho de Sociedades from Universidad de los Andes, and our students and the leaders of the Semillero, who are joining us today as well, and all the students and the general public is joining us today. I want to also give a warm welcome to Mr. Sergio Londoño, who is the director of the Semillero de Derecho de Sociedades. Sergio, if you want to give a couple of words before we give the floor to Professor Palmeter.
Of course, and thank you, Sebastian, for the introduction. And Professor Palmeter, we are very glad to have you here at Universidad de los Andes in Colombia. As I'm sure Sebastian has told you, Colombian corporate law has looked constantly to Delaware precedent and to the evolution of Delaware corporate law since the creation of a specialized business court some 12 years ago. And Colombian precedent has constantly referenced Delaware case law for the evolution of our local corporate law. So we are very glad to have you here and pick your brain on this momentous chapter that Delaware law is experiencing, because we are sure that what happens there will have some bearing on the development of our corporate law. Our students at Universidad de los Andes are very happy to have you here. So welcome. This is your floor, and I would also like to introduce you to Juan Pablo Amaya, lecturer of corporate law here at Universidad de los Andes, with whom, along with Sebastian, helped us organize this conference. And again, I thank you for joining us today.
Thanks so much.
Thanks a lot, Sergio, and obviously Juan Pablo, who is also going to provide comments on the talk. So, without further ado, Professor Palmeter, Alan, you are very welcome always in Colombia, either virtually or in presence. We know that you are very close to Colombia for many reasons, and your friendship with this country and with our professionals of the corporate law is always very welcome. So thank you so much for joining us. Professor Palmeter does not require any formal introduction to Colombians. We have all read your kind papers, your prologues to Professor Francisco Reyes's work. So you are very very well known to us and our public. So I'll give the floor to you to lead us through this very interesting talk. Thank you very much.
Sebastian, Sergio, Juan Pablo, thank you so much. So my history with Los Andes and with Francisco goes back 30 years. It was in 1994 that I visited as a Fulbright scholar at Los Andes, and that began a friendship that has lasted these now into 4 decades. I should tell you that I'm sitting in Winston-Salem, but my background is a country home outside Medellin in Santa Elena. So I thought I'd bring a little bit of the paisa to this meeting in Bogota. And Sebastian, I was so thankful that you said this would be a talk in English. My wife, as she was leaving, said, "So is it English or Spanish?" And I said, "I think I could do Spanish, but I don't know much of the terminology." So we're going with English, and I appreciate it. My plan is to talk for about 40 minutes. I then hope to have a conversation. And some people call it a question and answer. I think that's kind of a little bit pretentious that a speaker would have answers. I have as many questions as I have answers. So I'm going to share my screen, if that's all right, and begin with a PowerPoint presentation that I hope will be visible and will help give you some sort of orientation for my thinking. The question that I was presented, that Sebastian presented, was what's happening in Delaware? And what's happening with this rechartering of Tesla from Delaware to Texas? I believe that this event, which was the subject of a conference not too long ago in New York City that I attended, it will be the subject of a conference in Italy that I also plan to participate in, is the tip of an iceberg. That is, the question of Tesla moving from Delaware to Texas is to begin to notice, to see only a little bit of a monumental change, not only in corporate law, but I believe in modernity. So this is, in some sense, a small conversation about the question of reincorporation in the United States, but a much larger conversation about what I see as a transition that we are going through. We can't help but think about the political world and to think about the world in which we live, the natural world. So here we go. Let me see if this will work. My talk. I have 3 stories. The first story is this story of Tesla moving from Delaware to Texas. So to understand this, I think it would be useful to step back and talk about US corporate federalism, the question of how in the United States, corporate authority is allocated between the federal government and the state government, with Delaware having the primary role in creating the corporate governance norms under state law. So what has been the role of Delaware? And not only is it interesting to look at this historically, but also sort of in terms of why it is that Delaware is preferred in a market for corporate chartering. So it's curious. In the United States, we are into markets and we actually sell corporate law. Delaware sells a franchise. It says, come to Delaware, file your certificate of incorporation here, and you get a package of services. There's some recent data that I think will illuminate whether this move of Tesla from Delaware to Texas is really that big of a deal. I don't think it is. But I think it is in terms of exposing the story. And the story, for me, is one of Delaware and ESG, Delaware and the environmental social governance, the sustainability, the corporate sustainability movement that goes beyond shareholder primacy, goes beyond the idea that the corporation is this relationship between shareholders, the capitalist investors, and the management that runs the operations using all sorts of inputs. This shareholder primacy model is under attack, as it should be, I believe, because it narrowly conceives of the corporation as employs workers as being factors of production. They're humans. We're humans. As nature being some resource that we use, and we have unlimited amounts of this resource. It's a construct that I think is failing. I want to tell you the story of how Delaware is coming to this sort of awareness that the corporation is more than a relationship between shareholders and management. The Caremark case from 1996, and a series of cases illustrate this sort of arrival. I also want to tell you the story as part of this Delaware and ESG that Delaware's embrace of a broader view of the corporation has come under a lot of criticism from the rear guard, from conservatives who say we have a way of approaching life, of approaching economic life, of approaching the corporation, and this is an illegitimate move into some kind of new world that the political forces have not adopted. This is a kind of sort of coup by an internal palace coup. I want to tell you about that criticism. And then finally, there is the story of the litigation that led to Tesla, to Elon Musk saying, I'm going to take my company from Delaware to Texas. There's no real change in the operations. What happens is that some papers that had been filed in Delaware are now refiled in Texas, and the relationship between shareholders and management and others, stakeholders, we can call them, is now subject to Texas law. So there is a litigation involving a $56 billion pay package, and Musk loses. He loses in Delaware in the Chancery Court before Kathleen McCormick. Kathleen McCormick, the first woman chancellor, wrote an amazing opinion that begins with, can the world's wealthiest man be paid $56 billion? And her answer is no. This was unfair. It was unfair in process, unfair in price. And the response is Tesla reincorporates. My view is that that is the iceberg. The iceberg is this great conflict, this great coming together of two forces, the rearguard forces of Musk and the forward vanguard force of McCormick, a man and a woman. If you stop and think about it, what has been the greatest social change, economic change in the last 100 years? The arrival of women in the workplace, at the ballot box, in places of power. We're in a new age, and I want to talk about that. I see this as a great transition. The age of reason, the Enlightenment, that begins more or less around 1600, takes full form in 1800, becomes the engine for our capitalism, for our neoliberalism, is very much a left-brained male phenomenon. We are in the age of Voltaire 3.0 or 4.0, I'm not sure. But this age of reason has failed us. And if you look at the political landscape in this country, elsewhere in the world, if you look at the climate landscape, the natural landscape, we have not adapted to our circumstances. I believe that there is a strong movement to return to the age of faith. to the age of powerful lords, Lord Trump, who will save us from the mess that we seem to have gotten into? Or do we turn to our Oriental heritage, one of greater awareness, one that recognizes our place in the cosmos, our place with nature, our place with ourselves, moving from a left-brained, mechanistic orientation to a right-brained, holistic orientation? I think those are the stakes. That's the iceberg. So let me go back now and return us and make sure that I'm also more or less on schedule. Tesla is moved from Delaware to Texas. So there's Delaware, one of the smallest states, fewer than 1 million inhabitants, to Texas, the second largest state in terms of population, the new manufacturing center and headquarters for Tesla. And let's talk about this corporate move. So I have to introduce everyone, if you don't mind, to corporate federalism. It's a relationship between state law and federal law that begins with our corporations being chartered by state legislatures. They were acts of state. In the late 1700s, 1796, the first corporation, actually a water corporation in North Carolina, a private, non-municipal, non-religious, for-profit business chartered by the state. The Supreme Court in 1819 is asked, what are these corporations? And the court says, well, they're contracts, and they're also social institutions. They're creatures of state law, and they have their own kind of internal contractual essence. Which is it? Private property, a contract, or a social institution? We still don't know. We still don't know. Maybe both. State chartering becomes very easy through incorporation statutes, so you don't have to go to the legislature and bribe to become a corporation. State judges say, we've got to give minority protection. We will allow this to happen in derivative suits where one shareholder can say, I'm going to enforce the rights of the corporation in a fiduciary case, basically a case of anti-corruption. One shareholder speaks for the corporation in a derivative suit to enforce duties of loyalty and care owed by the managers, the directors, and officers to the corporation. The Sherman Antitrust Act says these corporations got way too much power. We're going to limit the monopolies and restraints of trade. Delaware kind of falls into the role of being the leading incorporation state. It had been New Jersey, but New Jersey tightened its rules under then Governor Woodrow Wilson and said, you cannot own other corporations. You cannot have a holding company structure. And so all of the Rockefeller and other big robber baron organizations moved from New Jersey to Delaware, which had copied the earlier New Jersey statute. Delaware then becomes the center for incorporation in the country and the center for describing this corporate relationship between shareholders and managers. Federal securities laws say state law is inadequate in giving us disclosure, so we have disclosure rules at the federal level. Delaware takes over the way in which takeovers happen in the United States. In some important decisions, it says, don't federalize corporate law here. We will handle this new economic phenomenon of takeovers. And the Supreme Court says, in a, I think, super critical case, says state takeover laws are basically sacrosanct. We believe in the idea of state corporate law. Citizens United says corporations can be political actors in the full sense of the word, except for voting. They can spend as much money on political issues as they want. And Delaware then begins to respond to the ESG movement, the idea that the corporation is much more than the relationship between shareholders and managers. There's corporate federalism. At the heart of it is the idea that the law of the state of incorporation, you incorporate in Delaware, but you have your operations elsewhere. Most public corporations have only limited operations or no operations in Delaware, but Delaware says the entire gamut of internal corporate affairs, shareholders, management, is subject to Delaware law. This is wise, practical, equitable, and in fact, this might be constitutional. The US Constitution may demand that if you choose Delaware law, that becomes the law wherever the case arises, whatever the circumstances. Delaware decides the relationship between management and shareholders, and you've chosen Delaware law. So the Delaware brand is powerful. The legislature had revamped its Delaware General Corporation Law in 1967, 47 times since then as well. Regular updates. It's the most reform-minded state in the nation. And there's also this idea you can't change the Delaware corporate law without a 2/3 majority vote. We don't want special interests in Delaware. There's a council of Delaware corporate lawyers that make reform proposals, and the Delaware judiciary, the heart of Delaware law, are experienced corporate lawyers, fluent in corporate affairs. There's a lower court, the Chancery Court, without juries that makes all these decisions, and they're swift, sophisticated, fact-driven, reasoned resolutions without juries, unlike every other state, except some states that are now trying to copy Delaware with their own business courts. The Delaware bar, highly sophisticated. Delaware, unlike most states, has its own bar exam, which emphasizes corporate law, and the bar takes turns being on this council, making sure that Delaware law serves the lawyers. So, is this good? There's an argument. Yes, Delaware attracts the most incorporations because shareholders like Delaware. There's a race to the top, or maybe this is a race to the bottom. Delaware is catering to management. And studies have looked at this since the 1960s and 70s, and the answer is the data is mixed. Delaware is clearly no better than other states, but not clearly worse, and the data depends on which time period and what you begin to look at. But Delaware continues to have this brand that is dominant. In fact, Delaware, is it losing startup and corporations? No, Delaware has a continuing leadership. 70% of Fortune 500 companies, the largest companies in the country and in the world, are franchise incorporated in Delaware, 90% of IPOs. And that, notice that data, more or less, nothing has changed in the last few years. Maybe a downtick, but it's a downtick where people are going to other states, not Nevada, not Texas, a few more states other than Delaware, but Delaware is still dominant. If you want to do an initial public offering, incorporate in Delaware because that's what shareholders know. And 50% of companies, the largest 3,000, have bylaws that say we want our lawsuits handled in Delaware. We've incorporated in Delaware. We want Delaware to be our exclusive venue. We don't want judges in other states to screw up what we've chosen. What about the rechartering story? So you say, well, everybody's leaving Delaware. No, Tesla left Delaware. And notice the capitalization, Tesla 706 billion. There have been a few other reincorporations, but they're small companies, mostly companies with a controlling shareholder. Almost all of these are companies leaving Delaware to go to Nevada, where controlling shareholders are given a lot more freedom and discretion on the theory that you have control, you paid for it, you deserve it, and minority shareholders can always sell if they don't like the company. So there have been 18 reincorporations to Delaware, some from Nevada, 19 reincorporations to Nevada, 16 from Delaware, through 2 incorporations, 1 Tesla. Reincorporation is not an issue. Delaware is not under attack. Delaware continues to dominate this market for corporate chartering. So what's happening? I believe this is about ESG. The reason for so much interest, so much curiosity, is what's happening to corporate sustainability. Our corporations, is capitalism healing itself? And that's sort of the driving question here. So I want to address the ESG beyond shareholder primacy, how this shows up in Delaware law, and give you a quick introduction to this rearguard criticism by, especially in a Wall Street Journal op-ed piece that's famous. A conservative Republican former attorney general in the both Bush and Trump administrations says Delaware is losing its place. I don't think he's right, but he's afraid of what Delaware is doing. So ESG in Delaware, here's the story. Back in the 60s, the Delaware Supreme Court says corporations, boards, worry only about shareholders. If there's something illegal happening in the company, for example, here, price setting, that was the argument that the board had not noticed price setting, basically taking advantage of customers. The board only need to investigate if there are red flags. You can be blind. Don't worry about your ESG, your social responsibilities. Then in 1996, there's a pretty dramatic shift. This is a Chancery Court decision, but it's William Allen, the greatest chancellor of all time, in many views, mine as well. And he says, no, corporations have social responsibilities. The board must monitor compliance with the law. If this company, Caremark, is bribing doctors to send business to them, then you have a duty to make sure that you don't violate the law, to monitor. It's duty of care. Delaware's Supreme Court says we agree, but this duty is actually a duty of good faith. It cannot be exculpated. So in a bank secrecy case, the Delaware Supreme Court agrees you have a social duty to make sure your company is in compliance with, in this case, banking law. Then we start getting a little strange. The Delaware Supreme Court in 2019 says a company that makes ice cream has to be sure the ice cream is safe. The board can become liable, the directors individually liable, for not being sure that the company wasn't selling listeria, ice cream laced with a disease rendering listeria. Then this is the big case. In 2023, Delaware's Chancery Court, and this is not McCormick, but another one of the vice chancellors, says officers have duties to monitor red flags of sexual misconduct. There are stories of sexual misconduct in McDonald's Corporation, and you, the officers, the chief financial officer, when you say our financials are okay, you have to be sure there's been no sexual misconduct and the possibility of big lawsuits against the company. This is such a change. So here comes Bill Barr. Some describe him as a bulldog. And he says, Delaware is trying hard to drive away corporations. He has this Wall Street Journal opinion, and he says, Delaware politicians are becoming pro-ESG. The Caremark doctrine, that case that I mentioned to you, William Allen, 1996, which had focus on corporate crime, is now getting into climate change, DEI, social activism. By the way, if I were at a university, a public university in the United States, receiving federal funds, my use of the word DEI at this moment might mean my university would not be able to get federal funding. That's how bad the rear guard is now. Former Chief Justice Leo Strine, a friend, he's saying, great, Caremark is a way for Delaware corporations to become more aware more sort of open to their role, social role, environmental role in the world. So the Court of Chancery is taking these ESG claims, shareholders saying you didn't pay attention to climate risk, you didn't pay attention to sexual abuse, you didn't pay attention to other ESG factors. And companies are now beginning to do this. And we see this where Disney now opposes a Florida law that is going to give parental rights in education. And Disney says, we're opposed to you forcing conservatism in education. So the consequences are Delaware is moving toward ESG, and we're moving away from shareholder value because that's what the corporation is for. That's its category. That's how you define a corporation. That's what notice, the left brain, male left brain thinks. A corporation is there for profits. Really? But what if it destroys the world? Well, that we don't worry about. So companies face litigation risks and they fail to align with ESG activism. Texas and other states now have specialized business courts. They can be an alternative. Move to Texas, basically, is saying Bill Barr. Nobody's paying attention to him. And these states are now trying to attract shareholders, but it's not really working that much. So Delaware is losing its privileged status, he says. The data doesn't support him. But there's the issue. Oh my God. Remember that old picture of Delaware Supreme Court? What do we have here? A Supreme Court with 2 women, an African-American man? At least the Chief Justice is still an old white guy. This is terrible. This is even worse. This is the trial court. This is the Chancery Court. No jury. These are the people that decide corporate law. Most decisions are not appealed. Oh my gosh. 1, 2, 3 women who are vice chancellors, 3 men, and then there's a retired Sam Glasscock who's still working. They've got a big workload. And look at this. A woman is the most powerful corporate jurist in the world. This is wrong. This can't be. Now my story. Does the body language say anything to you? Do I need to say anything more? About 60% of what we learn from people is their body language. You've been paying attention more to my body language than my words, if you're trying to figure out whether to believe me or not. The tone of my words is more important than the words themselves. Listen to the voice of each of these people. This is Elon Musk at the Republican National Convention saying, let's go, Trump. Let's make America great. Everybody wants to make America great. Was America ever great? Here's Kathleen McCormick. She's saying, Delaware, we shouldn't move too fast on responding to Tesla's reincorporation. You don't need to change the law. You don't need to have special interest law. We're doing just fine. So here's her opinion, saying that Elon Musk basically has stolen $56 billion from Tesla in his pay package. It's not a fair deal. He controls the company with 22% of the stock. He controls the board. The people who were on this compensation committee, in one case, he would regularly vacation with Gracias. He had a 15-year relationship with, I've forgotten the other person's name, but he controls these people. And he controls the process. the general counsel for the company, Ted Marin, his former divorce attorney, just a second, the largest auto manufacturer in the world, according to its capitalization, has a general counsel who had been a divorce lawyer. This is like the Middle Ages. This is like being back in the age of faith. This is like, the 13th century papacy. Ted Marin was moved to tears during his deposition because of his admiration for Trump. He's the one who's working for whom? The company? No, for Musk. There's no benchmarking. There's no time. The timeline is dictated by Musk. It's an unfair price. You don't need to pay him $56 billion. He's already got 22% of a highly successful company that will become even more, his value will go even up more. He doesn't need $56 billion. He's not even saying that he's going to leave Tesla. What do you need to retain him? Much, much less. And the stockholder vote was not informed. I'm not paying attention to it, says McCormick. And we're getting rid of this. We're rescinding his pay package. Just a second. Elon Musk is told by a woman, you can't get your way. When other women say you can't get your way, he just divorces them. When he was 14, a judge said, okay, your parents are getting divorced. He said, please don't send me with my mother. Musk says that McCormick is absolute corruption, an activist masquerading as a judge. She's DEI. She's a radical far-left activist. I told you I didn't need to show you the words. The body language said everything. Here we are. In our male-dominated left brain, viewing the world through little packages, all separate from each other. Economists always begin their arguments, all things being equal. Garbage. Never are things equal. You cannot separate one event from another event. Everything is connected. So what do? Things are falling apart. We return to an age of reason, of faith. We trust the Pope. We accept. And by the way, the Pope says, if you don't trust and accept me, you go to hell. Or we become more aware. We move to our right brain that is able to see things, that has intuition, that engages in creativity.
Thanks so much, Alan, for this very provocative talk.
So I should comment. I appreciate those words. The word provocative is interesting. In Spanish, it has a positive connotation, I think. In English, it has a negative connotation. I'll assume that we are in Colombia. Well, actually, it's maybe I've been provocative in both ways.
My Spanish speaking brain was acting right there.
Yeah, Alan, really.
Should I? And I think what I might do is I'm going to stop sharing my screen unless you see some reason to share.
No, that's all right, as you prefer.
Or maybe what I'll do is I'll leave this. I hope you can see me. This is the message. This is the iceberg. This is the question of our time. And the rechartering debate and Tesla movement to move from Delaware to Texas is what opens, I hope, an inquiry, a conversation, a new era.
Certainly, Ellen. Thank you so much for this wonderful presentation. It's very useful in helping us understand and navigate this critical moment in U.S. corporate governance. Um, One topic that has obviously sparked great interest among our students in Colombia is SB 21, right?
Yeah.
Its connection to the Elon Musk case, its intended goals, and its potential long-term impact on U.S. corporate law. Um, so we have a first question for you to explore the deeper implications of SB 21 and what it may mean for the future of corporate law in the U.S. Um,
Okay. So I first have to ask my research assistant,
yeah,
just one second, what is the current status of SB 21 in Delaware?
right.
I don't use ChatGPT. I use Perplexity, and Perplexity is really good. And if Perplexity gives an answer that I don't like, it's so obsequious. Oh, I'm so sorry. I didn't understand your question. It's the best research assistant ever.
Great, great.
It was signed into law on March 25th. Ugh. And this was so strange because the Delaware governor's office became interested in this law because it was buying into this Trumpist idea that Delaware is going to lose its 1/3 of its budget. 1/3 of Delaware's state budget depends on franchise taxes and incorporation fees.
Yeah,
Um, the Senate was unanimous. The House is 32-7, and it aims to strengthen Delaware's position by basically inviting corporations that have a dominant shareholder, a controlling shareholder, come here, and we're going to make uh, things between you and the corporation easier.
yeah.
It is actually a version of the Model Business Corporation Act, subchapter F. And that moves from looking at process and price to looking at just at process. By the way, McCormick could have used SB 21 to invalidate the Elon Musk pay package just as easily as she used Delaware common law, Delaware fiduciary law. So SB 21 appears to be a big change. It might not be.
All right. That's very interesting because what some critics are saying, some critics of SB 21, is that it marks a shift from Delaware's, traditional judge-driven approach to a more rigid statutory framework, and that this could potentially weaken the role of both the Court of Chancery and Delaware's competitive edge over other states, which you mentioned. So do you think
Yeah.
that SB 21's approach actually diminishes judicial discretion? And would that be positive? Because what some proponents of SB 21 say is that precisely when judges, overstep their boundaries or become overly creative, that's when the legislature should step in to prevent this from happening, right?
Especially women judges, right? These are great questions. Juan Pablo, let me answer because I've thought about them too. Let me see if my answer has any meaning. Um, SB 21, subchapter F, which I've studied. Um, it's can I make a quick plug?
Of course.
Sure.
It's covered in this book. So your examples and explanations turns out to be a book that Francisco knows about. It's the book that most U.S. law students read because their case books are so awful. So it turns out that SB 21 has words that basically seem to be statutory, but leave huge discretion to judges. For example, let's say the compensation committee in the Tesla case had a obligation to reasonably investigate whether the package was fair to the corporation. Okay. Give McCormick the word reasonable. She has all the clay in the world she needs. Then further, it says the pay package would be subject to, deference if there was an informed shareholder vote by a majority of the minority shareholders, by a majority of non-controlled shareholders. And again, what is informed? Give Kathleen McCormick the word informed, and she has enough clay, enough discretion to work with it. I believe SB 21 was meant to signal that we are going to rein in our judges. But that has yet to be seen because March 25th was apparently only last week. Juan Pablo, that was a great question.
It's a very interesting take, Alan. Thank you so much.
Alan, before we turn it to our students and audience, I would like to go back to the second story you talked about on ESG, and then perhaps pose a couple of questions on that front. The first one being whether you believe that we are really witnessing a shift towards real stakeholderism, or is it rather a shift towards what some have called enlightened shareholder value, where the interests of stakeholders can be considered and taken into account by insiders only if they are instrumental to maximizing shareholder value? What type of shift are we bearing witness to?
Sergio, I don't know. I don't know what's going to happen 2 seconds from now. I think your question is reasonable, rational, and mistaken. Your question is, what new category do we put the corporation into? And that's a problem because categories are limiting. They are delusional. Because once you say, that train is the fastest on the planet, there's an airplane. And once there's an airplane, there's a rocket ship. And then there's quantum entanglement, which scientists just said actually isn't instant, but it's faster than the speed of light. I don't know what we're moving into. I do know that there is a strong propensity of the current corporation to engage in greenwashing, because that's what people in business are told. You make your money by cheating. Bill Gates cheated. He was really good at it. It wasn't illegal what he did. He just always was breaking the rule just a little bit. And Microsoft became super valuable. Musk breaks the rule. You're supposed to make cars, by hand, and then you learn what you can automate. He said, we're going to automate everything first. He cheated. And so there's this, an MBA school, teaches externalize. Have somebody else pay these costs. I believe that there's a strong greenwashing imperative, but that it is balanced by finance, which is saying, we want real ESG. We want you to really pay attention to your carbon footprint, because if you do that, you're going to reduce costs. And by the way, you're going to help the rest of our portfolio. really pay attention to customers. Because if you do that, you'll get more customers. And if those customers' real needs are being satisfied, we won't have this, garbage of over consumerism. So, Sergio, I'm sorry to have placed you, as I often find myself being placed, in the age of reason. Everything is interconnected, and it's dangerous to begin to ask, what category are we in?
Fascinating, Alan. Thank you for your answer. And at the same time, one could argue that there are some hypotheses and some scenarios where we're not facing a win-win situation whereby when the company favors the interests of consumers, they are gaining and maximizing shareholder value. There
Right.
are some scenarios where trade-offs are present. And I believe that's where the real problems and real hard questions have
I
to be
think there's
asked.
some really hard questions. Ultimately, for me, a better framing is not what is the stock price, but does Gaia smile at this initiative? Does Mother Nature view this as a good idea? Maybe, for example, the Trump tariffs, which are going into effect as we speak, are a great way of slowing down neoliberalism. In the name of making America great, this president is going to put this country and perhaps the world into a recession. And the last time we were in a recession, carbon emissions fell dramatically. People in India said, here in our city, we can now see the Himalayas. We have never seen the Himalayas before. In other words, and I don't know, but for me, I think we frame the question of what trade-offs are in a way that doesn't take into account our relationship to nature and to each other.
Thanks, Alan. Thanks. This is really given that you speak perfect Spanish, estimulante. This is
Provocativo.
no. This is a great conversation. Earlier, you showed us one of your works, one of your books, which you kindly shared with us an excerpt previous to this session, so we could share with our students. And we prepared a little bit of a conversation with our students. And in our undergraduate basic corporations course, there was an interesting discussion we had with them regarding, quote unquote, the shareholder democracy, which is related to the Tornera decision and to SB 21 as well.
Yes.
And so we wanted to ask you, does this idea of the shareholder democracy exist? And what is the ultimate authority in Delaware corporations, or more generally in United States state corporations? Because for us in Colombia, we wonder, and this is a conversation with our students: is the ultimate authority in the directors, or in the shareholders, or even or even Delaware chancellors? And in comparison with Colombia, where the closed corporation, as you know, is the norm, and even in publicly traded corporations, we have very strong controlling shareholders. So is it possible to speak of a shareholder democracy in light of McCormick's decision and in light of these developments? Because in Colombia we have a sort of a controlling dictatorship.
Yeah. So the shareholder democracy question is a really interesting one. I'm glad you asked about it. The U.S. corporation and the U.S. Constitution grew up together in the early 1800s. And there are cases in corporate law that refer to political democracy, and there are political democracy cases that refer to corporate democracy, because both are almost identical hierarchical structures in which you say, we the people create this structure, we the shareholders create this structure, and the similarities in language is remarkable. The idea of shareholder democracy often is used to say, well, we have political democracy and we love it, even though I have questions about whether it functions. And shareholder democracy is something we should love because we're capitalists. But at the same time, every single capitalist who I have ever met is also human. And if you ask anyone who is an investor in a company, what's important to you, really important to you, they'll probably say, my parents, my wife, my grandchild. So, are you investing in a way that is consistent with what they hope for, their longings? We're beginning to recognize that the shareholder does not exist as a pure phenomenon. And I believe that and McCormick has a perfectly justifiable answer. She actually then turned down the pay package a second time in an opinion that said, even though there's been this cleansing vote, even though the shareholders were exposed to an account, my account of all of the failings in the process, I am not going to pay attention to that because this is an affront to human dignity. She doesn't use those words. But she's now thinking in terms of a holistic shareholder. And that's what I would, or a shareholder as a component of a holistic person. And that's what I would suggest is a better way to understand this question of shareholder democracy, to understand that these set of questions exist in larger contexts. Have I answered the question?
Yes, Alan, thanks.
I'm Sebastian. I'm not sure that I have. I'm going to think some more of your question. All of these have been brilliant.
So, sorry that we're just throwing them at you, but for us, it's really interesting to compare where the power in the corporation really lies. Our situation in Colombia is fairly simple. I think in the US, after these decisions, the question can be sort of opened again.
I think the corporation exists. I think our political system exists in each of our own perceptions. For example, there are many people who say constitutional law is in shambles, is falling apart in the United States. And my answer is, it's not constitutional law. It's how people perceive their relationship in this political system, in this political structure. And that's been going through some changes. So where does power exist in the corporation? I think it exists where we perceive it to exist. And McCormick has a perception that is different from Elon Musk's. And it may be that there are judges in Colombia that are reevaluating their perceptions of where power exists.
Sure. No, thanks a lot. Thanks a lot, Alan. This is great. There, I see that the public that there was an invitation to pose questions. We've received some questions, but there is one person in the public who has their hand raised. I've been texting this person. I don't know if this is intentional. Your hand is raised, Sebastian. Um,
Hi, Sebastian. Yes, I wasn't able to place my question on the chat. I'm sorry. I think it's
Thanks.
disabled at least for me, or I don't know.
I think if Alan agrees, I think we can give the floor to you so you can ask your question.
I think one Sebastian has discretion to decide on another Sebastian.
Thanks. Adelante, Sebastián.
Thank you very much. So, thank you very much, Professor Palmer, for your certainly enlightening and also provocative well explanation. And so I wonder, Professor, if starting from the stance that you pose from resting away of importance to William Barr's and Jonathan Berry's opinion for the data currently not supporting the incorporation shift to other states, won't that leave aside the possibility that as the political cultural war increases, using like Antonio Gramsci's terms, the data might possibly in a future effectively show that shift? And so my question concretely would be, what can be done today to avoid that drawback in that possible red state attractive corporate statutes might have, if you think that that should be even pursued?
For me, the data, preliminary data, is that William Barr was predicting something that is not happening, except that Elon Musk decided to pick up on his anti-ESG, anti-DEI rhetoric. But let's imagine that this becomes a growing phenomenon, that large companies leave Delaware because of a perceived ESG sort of preference or an ESG leaning. And I'm not sure that will happen. It requires shareholder vote. Elon Musk's move from Delaware to Texas did not get the required 2/3 majority vote that's required if you change the articles, but it did get a 62% vote, which is enough for a merger. So it was really a pretty close vote. And McCormick had to decide that 62% was enough, even though it wasn't 2/3 vote for changing the charter, I think in part to get rid of Elon. Just go away. But we haven't seen other companies doing it. Okay, so Zuckerberg at Meta is saying he might do the same thing. He doesn't like DEI either, it seems. But in the end, the real power center is the large institutional shareholders. What Vanguard, BlackRock, State Street in the United States, who control 25% of these companies, what they decide is what will happen. So, Sebastian, let's sort of keep our eyes open. If you have any relatives who invest in Vanguard, tell them to put pressure on Vanguard to pay attention to what you want, what they want.
Thank you very much.
Thank you, Alan. Thank you. I see that there's another question from Rafael, who's a very esteemed colleague of ours. So, Rafa, the floor is yours.
Thank you, Juan Pablo, and thank you, Sergio, Sebastián, for this opportunity to have this talk with Professor Palmer. So, Professor, thank you very much for what you have told us. I have a question. It is, what's the role of ethics here? I mean, what do you think about it? Because my point of view is that sometimes being more ethical is not attractive for business. So we see, for example, that I mean, I guess that was what Elon Musk was thinking. He said, "I prefer to move to Texas, where the law is not as ethical as I want." So, how can we make ethics more attractive? Uh, I don't know if you understand the question. Thank you.
I think it's a great question.
Thanks.
It is an enormous question. And so if my face seemed confused, it was how do I deal with such an enormous, great question? Let's move the vocabulary a little bit. Instead of talking about ethics, let's talk about morality. So ethics is, the set of rules that, people in business, and Enron had a great code of ethics, but it didn't have morality. And how do we open ourselves and others to the other? I'll give you an answer. I told some students yesterday, I'm going to write a love letter to Kathleen McCormick. Kathleen, I don't know if you know of me, I know of you. And what you did was so courageous, and I can feel how frightened you were. That's the best answer I can give.
Thanks, Alan, for and that's a very interesting answer, and this has been a very interesting talk for all of us, and we especially from Facultad de Derecho, Universidad de los Andes, and the Semillero de Derecho Societario. We want to thank you so much for your time. You have been so kind in sharing with us your time, your ideas, and not only sharing, gifting them to us. We really appreciate this. Obviously it's a great pleasure for us to talk to you always, and as we said earlier, you are a very good friend of us Colombians. You are obviously very welcome always, and given you have this beautiful house in near Medellin, and so
It's not.
thanks.
This is my wife's family. I cannot claim ownership.
No, great, and obviously you are part of us, and so thank you so much.
Can I finish with one quick comment?
Of course.
Juan Pablo, maybe it's directed to you. A few years ago, Francisco Reyes came to visit, and Francisco said, "So what's on your mind? What are you thinking about?" And it was during my sort of recognition that ESG might be real. And Francisco said, "But don't tell me, because it's going to upset everything that I think."
Of course.
And so I'd leave with that thought. Um, I appreciate being a provocateur.
Thank you very much for that, Alan.
Thank you
Thank you
so
very much
much.
for that.
This was very interesting, Alan. Thank you so much. We could stay here, asking a lot of questions throughout the day, but we've already taken
I
a lot of
invite
your time.
a lot of people have stayed on. It's all on these Zoom calls. We get a kind of vote because people begin to drop away, and you sort of know what's happening. For those of you who are still here, please know that I would love to hear from you, because by and large, you hold so much more in your hands by being younger than any of us do. So thank you.
Oh, that is so true, Alan, and thanks. And on behalf of our students, because the idea of this is really directed to our students, and they were very excited to hear from an absolute expert such as yourself. So thank you very much for your gift, Alan.
Thank you for inviting me. Thanks so much.
Thanks.
Thank
Thanks
you,
to all.
Alan.
And to get to meet so many people. Rafael,
Thanks a lot. Thanks a lot.
el gusto es mío.